There are millions of acres of opportunity out there. They belong to you. Every day, decisions are being made that affect your land, your water, your wildlife. You should know about them. This is your mountain. Hello, everybody. It is the middle of December, 2018.
Snowing again.
Every
time I drive over here.
And you're here for another episode of the Your Mountain podcast. And we thank you for being here, as always. All of us are here. Nephi Cole's here.
Yep, still.
Mike McGrady's here.
Yep.
Mike's always here because it's recorded at his house.
Yeah.
But roads were a little perilous for Nephi.
Good thing I drove my monster truck.
Yeah, you made it.
Of course I did.
Yeah. Thanks, everybody. Thanks, everybody, for being here. Thanks, everybody, for listening. We've got I think it's going to be a fascinating story to tell tonight. Before I do that, I want to remind everybody, if you're liking what you're hearing, you go out wherever you're getting this podcast and give us a rating. Leave us a comment. Give us a good rating, preferably. But give us a rating. Leave us a comment. Subscribe to this podcast. Tell your friends about it. Help get the listenership out. That's what motivates us to keep putting out this content for you. And we've got good content tonight. So, without further ado,
Story time.
So, we've got a lot of hunters and anglers that listen to this show, right? We're all hunters and anglers ourselves. We've become accustomed to understanding the way this world of hunting and angling works in the United States, the North American model. Tonight we're going to tell you a story about hunting. And this story is about to be told before the United States Supreme Court on January 8th, 2019. There's a hunting story. There's a hunting story that's going to be told before all 9 justices of the U.S. Supreme Court. And we want to tell you that story because that hunting story, depending on what the court decides to do with it, has a chance to, I'm not going to say fundamentally alter, but it certainly has a chance to impact the way the North American model of wildlife conservation is applied in many states in the West.
Yeah, we've become very comfortable with the paradigm that we live in. It's, we assume, and, for our entire lives, everybody listening to this, it's been one way. And so we just believe that that's the way that you just assume that that's the way it is, that's the way it was, that that's the way it will be, that's the way that it should be. There isn't a whole lot of discussion or thought that, acts, a variety of different acts by different branches of government could really affect what we get on the weekends.
Yeah. So let me tell you this story. I'm going to tell you the story that is going to be told before the United States Supreme Court. And then we're going to tell you why. So this is a story that takes place in northern Wyoming.
Allegedly.
No,
I'm just kidding.
Not allegedly. This story takes place in northern Wyoming, in the Bighorn Mountains of northern Wyoming. And it involves 3 hunters that entered the Bighorn Mountains in January of 2014.
So guys go up in January
of 2014.
They're out there for the purpose of hunting.
They're out there to hunt.
Which already sounds different than most of us get to.
A lot of folks are thinking, well, what are you hunting in January? Well, these folks are hunting elk, right? So they hunt elk January of 2014, and they see a large herd of elk.
So there's some guys
see
a big herd of
guys.
elk.
Yep. So they see a herd of elk, and they start pursuing that herd of elk.
Mm-hmm.
And they track that herd for a while, and ultimately they catch up to that herd of elk. And the 3 guys shoot at that herd of elk, and they kill 4 elk.
So 3 guys run into a herd of elk in January, and put 4 of them down?
Well, so that's the thing. So you got 3 guys, and they put 4 elk down. They kill 4 bull elk. They don't realize they've killed 4. They think they've killed 3. They pack those 3 out, allegedly pack those 3 out. Maybe all of it, maybe not. They pack
So
those
it's in
3 out.
dispute.
There's some dispute about how much of the animals were packed out. And ultimately, what happens is a Wyoming game warden gets a tip that this activity happened, that these elk were taken out of season because the season ended in November of 2013. So 2 months after the season ended, you had these guys up here in the Bighorn Mountains, and they killed these elk.
So for people that don't think that game wardens, so maybe this is just a side note, don't think that game wardens are working when it's not in season. These guys are out there, year round, looking for trying to figure out what's going on, watching the animals, watching the herds, watching the message boards.
So this happens, right?
Yeah.
And we'll get to some more of the details of it as we get into the discussion more. But this happens. Game warden investigates it and talks to the individuals, presents them with all the evidence from the investigation, and has them dead to rights. I mean, he's got a picture of one of the guys holding his elk, and he matches that to the exact spot where this elk was killed. I mean, he's got forensic evidence. He finally gets an admission. This seems like an airtight.
So the game warden does all the homework to get out to the spot, to take the same pictures, to do everything. So he's like, no, this is where it's at.
Found the carcasses, so the scene of the crime, this seems like an airtight, open and closed. I hate to say run-of-the-mill because you hate to talk about poaching in the context of run-of-the-mill because it's unfortunate that it happens at all.
So the game warden...
But it's a basic poaching case. I mean, it's a out-of-season, no license, illegal harvest of a big game
So
animal.
hypothetically or allegedly, the game warden finds all the information, finds the background, puts all the pieces together to know this is how many elk were taken, gets out there on the ground, collects all the evidence, and then identifies the individuals and heads out to do what game wardens do, which is, allegedly or hypothetically to make the, to carry justice forward, whatever you want to say.
Absolutely. So that sounds pretty. That sounds pretty.
Am I good?
Yeah, that sounds
the story
pretty,
so far. I'm getting the story.
You are. You got it.
Okay.
And that sounds pretty cut and dry. That's the case. So why in the world does a poaching case
why is
like
this in front of the U.S. Supreme
in front
Court?
of the U.S. Supreme Court? Well, what if I told you that those 3 people that killed these elk were actually members of the Crow tribe, and lived on the Crow reservation in Montana, which is the Crow reservation shares the border with the state of Wyoming on the northern border within the borders of Montana, and is adjacent to the Bighorn Range in Wyoming. So from a geographic standpoint, we're touching, right?
Okay.
So, 1, what if I tell you they're tribal members? And 2, those tribal members knew they were coming into Wyoming. So they came across the border. They knew they were in Wyoming, at least a mile deep in Wyoming where they killed these elk. So I'm telling you that.
So here's a question for you. So then
Yeah.
on the reservation, if they're on the reservation, they could be hunting on the reservation on January 18th. That's all good. It's all kosher.
So my understanding is yes, that as a tribal member, they have an opportunity. They would have been fine. As a tribal member on the Crow reservation, the way I understand it is there is not a lot of regulation of hunting.
But now we have 3 guys who, when they're not there, when they're in Wyoming, they're just dudes without tags.
They're guys without tags, right? And so I have that piece. Now what if I tell you that 2 of the 3 guys, when confronted by the Game and Fish Department of Wyoming about this, said, "I'll take my ticket. Yep, I did it. I admit I did it. I'm going to take my ticket." And what if I tell you the 3rd guy is a game warden for the Crow tribe? And that game warden for the Crow tribe, at one point, actually after having harvested this animal, after having killed this animal in the Bighorns, but before being contacted by the Wyoming game warden about this, actually sent an email to the Wyoming game warden and said, hey, I'd like to consult with you. I understand that there's some tribal members poaching elk in Wyoming, and I want to coordinate with you on how we address this issue. You know, so there. But at the same time, he's gone out there and done this.
So guy number 3 calls up the game warden and says, and this is before the game warden knows anything about this. Then
this is before the game warden knows that
knows anything.
Knows anything.
He just calls up and says, "Hey, I wanted to talk."
It's like
with you
interstate
about
coordination, interstate cooperation. We do it all the time. You know,
Yeah.
we want to work with agencies in other states to help solve wildlife crimes. We have interstate compacts that allow us to do it, and this
Yeah.
is an opportunity to work with the tribe on something like that. And so he was approached by this game warden from the tribe that wanted to talk about addressing some of these poaching issues that were occurring along the state line.
I'm following you. It's getting more interesting now.
Yeah. So it's about to get a little more interesting. So the last thing I'd tell you, and really the reason why this story is going to wind up in front of the U.S. Supreme Court is, I told you 2 of the 3 guys said, I'll take my ticket. The third guy, the game warden in Montana, said, I'm not going to take that ticket. I have a right. I have a treaty right to hunt on these lands in Wyoming. And when he says I have a treaty right, what he's talking about is in 1868, the United States government entered into a treaty with the Crow tribe establishing the Crow Reservation.
So you're backpedaling a little bit.
I'm backpedaling.
No, I'm going to backpedal a little bit. That's what you're telling me now. So the individual from the reservation contacts law enforcement on the Wyoming side, the game warden. Game warden, because this becomes suspicious, then goes out and does his investigating, puts all the pieces together, says, nope, I got it, finds the things that he needs to find, hands out a couple citations, goes to hand out citation number 3 and guy number 3 says, I have a right to hunt because of a treaty from 18...
Yeah, and so
did I miss something?
I'm going to give you a couple other facts to mix into this, and they're not really relevant to the U.S. Supreme Court case, but they're interesting facts on the poaching case, that led to this treaty argument.
Yeah, just for Nephi's question, this wasn't like Perry Mason where it's an aha moment. It's okay, I got to try. The defense of the treaty right came later in time.
Okay,
right.
So during the court proceedings.
So at first. And I'd put it this way. I'm basing it on my interpretation of what I see, right? So I'm not putting words into the court or into any defendant or the prosecutor here. I'm not doing that at all. But when I'm looking through the facts of the case, and one of the facts of the case, one of the things, the trigger that led to this investigation was this game warden Cliven Herrera from the Crow tribe, posting a picture of the elk that he had killed out of season in Wyoming on a website.
A website. Yeah.
On a website. We'll just leave it at that. He posted it on a website that has like a brag board, right? It's a place to post and share animals that you get. He posted that and he said, "Great year on hunting on the reservation this year." So he was implying that he took that elk on the reservation.
The Wyoming warden,
and I would suggest that he implied that because he knew he wasn't supposed to take it on the Wyoming side.
And
but
the Wyoming warden said, that doesn't look like,
looks
like my area.
The Wyoming warden saw that picture and said, that looks an awful lot like an area in Wyoming. And they actually were able to take that picture and find the exact tree that picture was taken under in Wyoming, and then found the carcass, and that's how it was all put together. And then they found multiple carcasses, and they found a fourth. I mentioned early in the story they thought they killed 3 elk. Mm-hmm. Well, when the warden was up there, they found a 4th elk, head still attached, entire carcass still intact. That was shot full of holes.
For people that don't know, the wardens these guys are really good at their jobs. It's straight up CSI.
Oh no, absolutely. We have forensic labs, all sorts of stuff to deal with this. They didn't really need a forensics lab, but they used it. They were able to match some DNA from the site to the animal because they had kept the head. Mm-hmm. Right. So they that's when I said early on they had an open and shut case. They really did. If it was a true just hunting out of season poaching.
Just 3 dudes.
But you throw in a treaty, right? and that adds a new wrinkle.
So what's the story with that? What does this mean? The treaty right?
So let's back up, and we'll go back into the 1850s, 1860s, right? And we'll talk about this a little bit, and I'm gonna say some of the things I'm gonna say are pretty in historical context, really frankly, pretty indefensible. So I mean, we are where we are today. Some of the actions that the U.S. government took in the 1850s and 1860s and 70s,
they don't seem very rosy in our present context.
They certainly don't. So there was a military strategy, right? There was a military strategy. The Army had a strategy.
So what year is this? So you're saying there's a...
So I'm talking we're starting in sort of the 1850 through 1870s kind of time frame, right? And this is a military strategy to address Plains Indians.
Mm-hmm. So we're talking the settlement of the West has occurred to a degree.
It's in the process of occurring.
People are, a lot of places aren't statehood, but there's definitely people coming across.
Yeah, and obviously you have the gold rush in California starting in 1849, and you've got
those dang Mormons,
the Mormon Trail kicking
still
up,
can't get them out of Utah still,
and the Oregon Trail kicking up, and you've got the Union Pacific starting its move in the 1870s, and so you've got a lot of this development and migration of folks west, and there was a lot of conflict with tribes as they're moving west, and battles, wars, being fought, and there was a strategic decision made, and the Army recognized that the tribes they weren't an agrarian economy, right? These tribes were nomadic. They were moving around. They survived on game and largely on bison and other large ungulates, right? That's how they survived. That was their shelter. That was their food. That was their clothing. It was everything to these tribes. And the Army recognized that. And the Army had made a strategic decision, especially with respect to the bison, said, we are going to, if we eradicate the bison, if we have a strategic military strategy of eradicating the bison, it will force these tribes onto reservations and force them to, frankly, become agrarian and assimilate to the sort of
the culture
that was coming, from the east, right?
Names. So give us some names in the Army, the people involved.
Yeah. So there were a number of people. There were commissions that were set up to negotiate these treaties with tribes. There was a peace commission. I don't remember the exact name of it, but it was really a peace commission. The whole idea was to establish peace with the tribes and to allow for development of the West. Right? And so there were a number of folks that were on this commission that were assigned to negotiate these treaties. And there's one name that really, as you dive through some of the history, that it comes up pretty frequently, and it's General Sherman.
Yeah, my mom hates that guy.
Why is that?
Because my mom loves to do genealogy, and we have a lot of family from the South. And you can't tell anything because all the records from wherever he went were burned. He just cut I'm dead serious. Just cut a giant swath across the South and burned everything of value, including records.
So General Sherman was one that was, and we're talking in the late 1860s here, was responsible for some of the treaties. And in fact, the treaty that we're talking about, which is the 1868 Fort Laramie Treaty, that's the treaty that created the Crow Reservation. It also created a number of other reservations, including a reservation for the Sioux in western South Dakota. And in that Sioux tribe, in that reservation, it had language in there that said the right to hunt on any lands of the North Platte and on the Republican Fork of the Smoky Hill River. So there will be retained those rights for the tribes so long as the buffalo may range thereon in such numbers as to justify the chase. So the language said, as long as there's game, the tribe can continue to hunt that game outside of the reservation.
You remove the buffalo?
So, Sherman was kind of furious. When you read through some of this history, he was furious with this language. He's absolutely opposed to that clause, because he wanted to clear this land of Native Americans, right? But when he was told, no, this clause is merely temporary because we're going to eradicate the bison, right? So this clause is temporary. Then he got on board with it. So, and this is where I prefaced that discussion at the beginning saying, I'm not defending the actions of, I'm relaying the story of history. We're not defending the actions of the U.S. Army during this time period, because they clearly went into these negotiations. We talk about good faith negotiations. When you read the historic,
there was some strategy.
There was some strategy, and there
background.
wasn't necessarily a lot of good faith going on in some of these,
or necessarily even bargaining power.
Right.
Yeah.
Certainly. Yeah. So that reservation was established at the exact same time as the Crow Reservation, under the same treaty, with the same negotiators who had this intent of, yep, we're going to allow some hunting off the reservation, but we recognize this is going to be temporary because our strategic military decision is we're going to eradicate those game species, and then they are going to be forced to stay confined on the reservation. That was the strategy, however perverse it may seem today. Right, that was the strategy at the time. So take that context and start looking at this Crow tribe treaty. It's worded slightly differently. It doesn't talk specifically to buffalo. It talks about having the ability to hunt the unoccupied lands of the federal government, right, for as long as game persists.
The exact wording was the unoccupied lands of the U.S., wasn't it?
Yeah, I think that's right. Not the federal government.
Yeah, and so it's really interesting because, if you think about it, when I go back to that time and I'm like, what were the unoccupied lands in 1868 versus what? I mean, you almost put a question mark like, so what are the unoccupied lands today where everything is managed, where everything has a deed and title and somebody's in charge of it? And we don't want to go there necessarily, but I'm just saying it's just a different world.
Yeah, but that's one of the questions. Is unoccupied...
What does it mean?
What does it mean? That's one of the questions before the Supreme Court. It doesn't necessarily mean, does having regulation on the lands, does the fact that we have FLIPMA and NIFMA and all the acronyms we talk about on these podcasts all the time.
Is that occupation?
Is that occupation?
Yeah,
that's
if you have
not
a wilderness area that has more rules associated with that wilderness area than there are for my backyard, is that unoccupied lands or is that managed lands? Is that...
And that's a question that the court is likely going to have to, consider during this argument. Those are arguments that have been made. One side, the Herrera and actually the U.S. government and others, supporting that side of the case have suggested that unoccupied simply means what it says, that people haven't settled it. They didn't homestead it. They're not living on it. And the federal government went through a process to take those lands out of land that could be available for occupation, and by their very nature are unoccupied. The flip side is exactly what you said. Is it occupied because we have grazing leases, we have irrigation ditches,
lodge,
we
ski
have
resort,
ski resorts, lodges, campgrounds, hiking trails, all of that sort of stuff.
Sure.
Yeah. Right.
You can't tell me this issue's never come up.
It's come up exactly.
Oh,
yeah.
okay.
No, beautiful segue. Why don't you take it? Yeah. Why don't you take it?
No, you take it.
Yeah. So this case actually, this has been addressed. There was a case. Well, there have been a couple, but in particular, a 10th Circuit Court of Appeals case. And for those that don't know, the court system is, at the federal level, is you would start at a federal district court level, which would be kind of your trial court. That's where you'd have the trial, right? And then you'd go to an appellate court, which would be your Circuit Court of Appeals, and then you'd go to the U.S. Supreme Court. And I tell you this, and then I'm going to tell you that that's not how this case arrived at the U.S. Supreme Court. It went through the state system and then arrived there.
Right.
And I don't know if we want to get into the legal nuances of why that
Suffice
happened.
it to say there are two pathways.
But there are different
general
pathways.
two pathways. through the federal system or through a state system when there's a federal question.
To get yourself before the U.S. Supreme Court.
Right.
But the Crow tribe actually, more than 20 years ago, had a case interpreting this treaty and this language of this treaty about hunting the unoccupied lands before the 10th Circuit Court of Appeals and lost. 10th Circuit Court of Appeals said when the state of Wyoming was granted statehood, that at that point, any claim that the tribe, it basically invalidated that treaty provision, right? And
it's because Wyoming. Now they didn't go as far as this, but is it because Wyoming was then quote unquote occupied, or it's just we don't know? It just was
Culmination of events that result in occupation.
Yeah.
Yeah. So it went through 10th Circuit, right? Never went to the U.S. Supreme Court, but that was kind of the settled law at the time. It was taken through the 10th Circuit, and the 10th Circuit said, statehood, dealt with that right. There was also a case from the late 1800s, 1896, that was dealing with treaty rights as well. That was also on point. That again, and I can't remember the specifics of that case. That case was Ward v. Racehorse, but it was another one that was similarly interpreting the hunting provisions of a treaty right, right? And interpret them in favor of the state and against the tribe. So you had those two cases. Then you had a third case that came on board. I don't even know how many years ago that was. It's called the Mill Locks case, and it was several years ago. I believe, was it out of Minnesota? It might have. Anyway, at least in that circuit,
Yeah.
In the upper Midwest. And it kind of turned this argument on its head a little bit. But it was interpreting a different treaty with different language. Right? And so here we are. We've got the Supreme Court that's going to be interpreting this case and this particular language. And, it's in some ways you look at it and think on a factual level, is this the factual situation that you want before the Supreme Court making it, interpreting a treaty right? A guy that when you read through a lot of the information, the allegations and the information behind this, that it seems that in his mind he wasn't arguing a treaty right at the time. That was coming later. He knew he wasn't supposed to be in Wyoming and went into Wyoming and killed these elk and then claimed this treaty right. A couple of other interesting facts, and I don't want it to sound like I'm pushing one side or the other of this case, but there are a couple of other interesting facts that are worth noting before we talk about kind of what this could do, depending on what the court decision says. What could this do? There are a couple of things I'd mention. First of all, it's the timing. A couple of things, right? So I want to go back to we were talking about this tribal treaty, 1868 treaty,
Yep.
right? Well, so the tribe had been exercising their treaty right for a little while anyway. But then in 1883, and one of the Crow chiefs at the time in 1883 went off of the reservation into Wyoming again. I feel like this always comes back to Wyoming on these issues, right? But went into Wyoming and was hunting off reservation in unoccupied lands. And the Army actually forced him back to the reservation, told him he couldn't hunt there. Right? That was 1883. By 1886, and there are some of the depositions from the prior case that I was mentioning from the 1990s, this 1995 case. There were some depositions and other court documents from that time that laid out the historical record here that would say in 1886 the Crow tribe ceased all off-reservation hunting for the next 100 years, and then it came back up again in the mid-90s, and now again. And so one of the things in that case that I mentioned is they had the ability to hunt so long as game persisted. Right? There are other interesting facts woven into this case. One of them being elk, the very thing that they were out hunting. Right? Elk ceased to exist in the Bighorns by about 1909.
So they were extirpated from that mountain range at that time. There was nothing there to hunt.
There was nothing there to hunt. They were put back in decades later by the Wyoming Game and Fish Department through license sales, through dollars, sportsman dollars provided through hunting licenses.
State management went in and
state management
reestablished those populations along with a system of rules and regulations to keep that wildlife at a sustainable level where could be harvested by the citizenry.
So there's a question: does the game persisting, if it goes away and then is brought back by other means, does that mean it continues to persist, and does that right continue to extend to that animal? That's a question. It's a sort of a nuance of this case, but something I thought I'd throw out there.
Yeah, what's really, I'm going to try not to get us too far off. What's really tough about a case like this is you do, raise questions like that, and they're harsh questions. Asking a question like that is saying hey, this, somebody had a right before we extirpated everything, but then when it came back, do they still have a right? Boy, these are not clean.
No, they're not. But if you go back, like I talked about, and like I continue to harp on this, not defending the action, right? Not defending the action. But the military strategy at the time was, as long as they persisted, the plan was these animals weren't going to persist long. It was going to be a short-term treaty provision. That was the intent of the military at the time. For right or wrong, that's what's in the record. And so, it's a fascinating case, and it's an important case, because if you think it just impacts land immediately surrounding this reservation in Montana and into Wyoming a little bit, you'd be mistaken.
So the argument, I think it's important to talk about before we talk about the scope of what it's going to affect, what would an argument, let's say the argument that Herrera, he wins his argument, what's the argument he's making? What does that allow tribal members to do?
The argument he's making? Well, the argument that he's making is that he has this treaty right that allows him to hunt the unoccupied lands of the United States, and that's without limitation.
So going after those elk in January, however many, if you're hunting them, all good.
Let's be clear. It's not just elk. It could be moose, bighorn sheep, black bear, mountain lion. It could be,
goats,
rabbits, goats.
Goats,
yeah, it could
bears,
be deer. It can be
hunting.
Whatever it is by definition game at the time the treaty was adopted. Not what we perceive as game today, but what they would have perceived as game at the time, right? So this doesn't just apply to elk. This applies to just about anything you can think of that would have existed at the time, and not just in the Bighorns. And that's where I think it's important to be clear.
So the scope of that treaty is large.
The scope of that treaty is large, and there are a number of other treaties that have identical language or very, very similar language that would affect federal lands. We're not just talking Forest Service. We're talking federal lands. So Forest Service, BLM, U.S. Fish and Wildlife Service.
The unoccupied lands of the U.S.
Could it potentially be national parks?
Nobody's defined, right? Unoccupied lands of the U.S. It remains undefined.
In the context
from
of this
the beginning
treaty,
until now.
In the context of this treaty, it's undefined, and that's one of the things that has to be defined. But with the other treaties that are out there, it could affect lands in Arizona, Colorado, Idaho, Montana, Nebraska, Nevada, New Mexico, North Dakota, South Dakota, Utah, and Wyoming. So we're not talking about a local impact. We're talking about a potential West-wide impact. And what is that impact? It's to be determined, right? But there are a number of potential
But now
outcomes.
Setting aside this argument, now talking about the potential outcomes, that's what gets really interesting, because now you're talking about, again, this paradigm that we've all become comfortable with, the North American model and how it works. And and the states are managing the game, and we're buying a tag and we're going out. But now you're talking about removing, or you're talking about a system that has somebody can come in now, and the balance is gone from that system. There is no regulatory. There's no regulatory scope.
Maybe. So I view there as. So I've looked at this, and I look at it as there are a number of possible outcomes on this, right? So you have one possible outcome is the Supreme Court sides with the state of Wyoming and some of the other states and state wildlife agencies that have come in and made the argument that the treaty provisions no longer apply because either one, the lands are occupied and have been, or two, that statehood invalidated that provision, or three, that this case has already been argued and they should be prohibited from making that argument again. They argued, lost, let's move on, right? So the Supreme Court could make that decision, and status quo prevails, state management, except within the reservation boundaries where there'd be tribal management, right?
What's that legal term called where it's already been argued?
Res judicata, or are you talking? We're talking like
it just like, sounds cool, so I don't want to make you say
okay.
it.
Yeah.
Okay. Yeah. All right. Yeah.
Go ahead.
Okay. So I was going to move on to the second piece. So another possible outcome is that ultimately, and this is ultimately because things could get remanded back to state court and go through processes. So we're just going on after all the court cases run their course. Here's what the possible outcome could be. Another one. So I gave you one. Another one could be the total opposite of that. The tribal right is recognized and is allowed, so the tribe is allowed to hunt on these unoccupied lands, and unoccupied lands could be all federal lands, and without reservation, meaning subject to whatever regulation the tribe wants to have, if they want to have any regulation.
If they do or
all.
do not.
And it would be at the discretion of the tribe, right? That is a potential outcome.
Yeah, so we have these two these maybe.
Don't call them outliers. They're two.
No, not outliers. I'm
just
saying we'd have two.
And I wouldn't call them extremes if that's where you're
going.
No,
just to say we have a scale, right? And
you have two. Those are two of the
opposite
possible
sides of the
outcomes.
scale, and now there's.
And I was going to give you a third
bunch of things in between that could end up as.
Well, so I really
different
think
levels of stuff.
I really think those are only about three reasonable outcomes to this. Those are two of them, and the third one. And this is all just speculation, right? But I think reasonable speculation is that the court recognizes the existence of a tribal right, that this treaty right exists, but that treaty right becomes subject to reasonable regulation under the state system in which they are wanting to exercise that right. So it would require, in that type of circumstance, it's recognizing that
it has to fall
that situations on the ground have changed from the 1860s to today in wildlife management. That we went from no wildlife management because there weren't a ton of people and it seemed like a limitless resource to we had to have very tight management to bring populations back from the brink of extinction and then to manage a resource for the benefit of future populations, i.e. the North American model, right? So we have, out of necessity, built this system to regulate and manage wildlife, and because of that necessity, we have to figure out how to fit that tribal right into that system, which would then require the states to coordinate with the tribes and come up with an allocation of state licenses to tribal members every year to be able to exercise that right.
You as an attorney should really like option number 3 because it sounds like a lot more work.
Option number 3 is
figuring it out over multiple years and many other lawsuits.
Option number 3 isn't inventing anything new. Option number 3 is in existence in several states right now that are dealing with the exercise of tribal treaty rights. That have different language than this particular treaty, but they have language that allow that recognize traditional hunting rights on traditional grounds. And so, chime in. I feel like I've dominated this. Chime in if you think I'm missing a possible outcome. Those are the three that I see as possible outcomes.
Yeah, I'd agree with that.
I think it's fascinating. I just don't think, I think that to me, I mean, you look at the three outcomes, but to me, I don't see three outcomes. I see Pandora's box.
Why's that?
I just think there's so much that can change and there's so much that can happen. And I think that, I find it perilous in my mind. I've become really comfortable with the way
you're giving a lot of verbose language here without any substance behind it.
It's just
give us something. What are you thinking?
Well, I just don't. I think that like you said, I think when you start talking about the age of that treaty and the way that it was developed at the time, and trying to find a way to pigeonhole that into today, things like unoccupied lands of the U.S. and all those things in the background, I think that there's so much that could be to be considered and to be weighed in on and to be discussed, that this case, I don't know that this case is a great case for making any and all of those arguments. And I think that's what makes it a scary proposition, is because
I'm about to do something to you here.
Go ahead. Go ahead.
I'm just going to push back a little, because you're saying, like pushing this treaty from 100, from 1868 into the circumstances of today, and it makes you nervous. Is how I'm interpreting what you're saying, right? I'm just going to say three words: United States Constitution. Right? I'm just saying United States. So I say those three words because we have a document that was created at a time that is a lot different from today.
Being interpreted.
Being interpreted.
Yeah.
I
think it's different. I mean, I understand what you're saying, but I do think it's different because I think that document, there's a whole lot of care put into that one, and there's a lot of care put into. So here's how they're similar. The United States Constitution, right? It's the guiding principle, the guiding document, effectively creating our society that we see today. It's creating our system of government. It's creating our country. It's creating our judicial branch. It's creating our rights. It's creating everything. What did that treaty do for the Crow tribe? What was it doing? It's establishing the
rules
that they had to live in. It was doing the same
thing. It was trying to do. The idea was to do the same thing, right? It was on a miniature scale, on a different scale. The idea with the treaty was to say, we are outlining the boundaries of your sovereign, and we are going to recognize your sovereign and your rights. We're establishing those rights. It's not 100% analogous, but it's a document that was created to establish a sovereign.
One of my favorite sayings, Dave, is you take a complex issue and put it in front of somebody. As soon as they tell you that it's simple and they understand it, then that they're BSing you.
Yeah, that's true.
Because to me, that's what it is. Like, we can try and put this case in a box, but the history is so complex.
It is complex.
And the things that we cannot escape are that, as much as, I think legally if the legalese could be like, okay, let's look at this equation and X and Y, and let's look at these, arguments and things like that. The things that cannot capture is that cannot capture the culture of the time, and it cannot capture I don't think adequately the culture of today and the thought process that goes into the decision makers of today, be it at whatever level government they're at. When they look back, like we've been talking about the past, and we say, hey, we can't defend what Sherman did and what the Army did and everything like that. Mm-hmm. But you are going to see people today, they're going to say, you know what, that was indefensible. And those guys might have had that, as their strategy, but I'm taking a look at it today and I feel differently than they did at the time. And that's not those feelings and those issues of today, that perspective, that modern perspective is going to add something to this that's going to be different than a clinical, surgical, look at at the points of the law. And maybe it's not.
Justice
but you
Scalia
gotta. Yes, he would. Yes, he would.
Justice Scalia would suggest that you shouldn't care about either one of those things.
He would, but is it fair to say though that now let's look at this Supreme Court that is, that is a lot of, conservatives love the Supreme Court, but we have justices on the Supreme Court that are conservative justices who have who may have differences of opinion than previous justices that have been on there. I mean, you can never really accurately predict everything about the personality of a court as a whole until you get there and you have the argument, and it is all on the table along with the personalities of all the people who are going to be making that decision. It's a really challenging issue, I think.
This from our judicial correspondent, Nephi Cole.
You're not wrong, Nephi.
No, you're not.
But you still don't know after argument.
Thank you, Mike.
Until the opinion comes out.
And when is that going to happen, Mike?
By the end of June.
End of June.
2019 is what I would predict.
And why is that?
Typically, they write up their opinions on everything all the arguments they've heard from October of one year through May or so of the following year. They get them all out and done.
It's also probably worth noting just briefly, very quickly, that it's unusual for the Supreme Court to take a case. I mean, that's weird for me to say it that way.
Sure.
But
they get 10,000 applications for people to come in, and they only take 80, 75, 80.
And
so a case like this.
That's one of the reasons I say what I said, because, why is this case in front of the Supreme Court? Somebody already weighed in and said, we should hear this. Even though everybody's arguing that it's already in stone, we should have the discussion. Who was the person that, who stuck their thumb on the scale and said, maybe the courts should listen to this?
It was actually the government of the United States.
And so if you think that this is a done deal, and we're just going to...
General's office.
The Solicitor General's office said, hey, you know what? I know that you guys all thought this was settled law for the last 100 years, but maybe we talk about it again. That's what I mean when you talk about the culture of today versus the culture of then. And for us as hunters and fishermen, you have to go, okay, how's my world changed in the last 100 years? Is it going to change again?
This is a case that, I mean, it could go, like we said, it can go several different directions. This is a case that, as sportsmen, if you're listening to this podcast, this is a case you should be watching pretty closely.
You care about this.
It's Herrera. Is it Herrera v. Wyoming?
It is.
I think it's Herrera v. Wyoming is what it's called. Anyway, this is a case that you should monitor, especially if you hunt in the West, because the outcome will have the ability to your opportunities in the West. If two of those three scenarios I provided to you occur, one being the tribe having the ability to hunt on unoccupied lands without restriction, or two, with reasonable regulation under a state system, either one of those,
it's going to affect your tags.
It's going to affect the allocation of licenses available for the general public to hunt a number of species in these states. So it could certainly impact opportunity. And it's worth monitoring, and that's why we wanted to have this discussion today. That's why I wanted to tell you about this interesting hunting story that's made its way all the way up to the United States Supreme Court.
Super interesting.
So, with that, take a look, watch for information about this case in early January when it's argued. You'll be able to listen to it. I don't know if it's live streamed, but you'll be able to listen to the argument if you want. The briefs, if you want to read up more on this, we'll probably post information about it on our social media sites, which are all the usual places at It's Your Mountain. So we'll post links for you to be able to read the briefs, more information about the case if you'd like to, and then keep checking back for updates. Watch this closely. In the meantime, just remember, life is about experiences, so go have one.